Bonjour à toutes et à tous. Hello, everyone, and welcome to the virtual edition of We Robot 2020, the premier international conference on law and policy relating to robotics, hosted this year by the University of Ottawa Centre for Law, Technology and Society. Now, reinvented in the times of COVID-19, We Robot 2020 is presented with the generous support of Microsoft, CIFAR, X, and Intel, as well as the University of Ottawa, the University of Washington Technology Policy Lab, and Miami Law. For those of you who aren't familiar with the We Robot format, please note that the authors do not present their own work. Instead, session discussants read the author's paper in advance of the conference and present the author's work to the audience while offering constructive thoughts for improvement and seeding the conversation that follows. Authors will then have 5 minutes to respond to discussants' feedback, and the session opens up to the floor. For the virtual edition, we invite the audience to engage with the paper in the comment section below the video. All right, so my name is Katie from the University of Ottawa, and for this upcoming session, we are just delighted to welcome as our discussant, John Penny, who is an associate professor at Osgoode Hall Law School at York University. And he will present Reconciling Legal and Technical Approaches to Algorithmic Bias. This paper is by Alice Chang from Partnership on AI. A link to the paper will be available underneath the video. All right, so I'll turn it over to you, John, to give us your initial comments as you take us through Alice's paper.
Thank you so much, and it's fantastic to be here on We Robot 2020 virtual Zoom edition, and really is an honor to have a chance to comment on this paper that I really enjoyed. I think it makes a significant contribution, and really for the challenge of scholarship in this context is that in order to do this kind of work concerning machine learning and algorithmic bias, as Alice has done in this context, you really need interdisciplinary expertise. And this is what you have in this paper. On the one hand, of course, understanding the complexities of US anti-discrimination law, itself requires study and in-depth expertise, but then considering algorithmic systems, decision-making, bias and fairness, and the sophisticated underlying processes, statistical modeling, the technical nature of the literature, of course, that too requires a sophisticated level of expertise. And Alice has combined this really in a lovely way in this paper and seamlessly weaves and combines multiple literatures into coming with, I think, a really nice solution with some core problems facing anti-discrimination law in the United States in relation to complex challenges of algorithmic biases. So I'm going to start. I'm not going to spend the full 10 minutes here. I'm looking forward to discussion with Alice. So I'll briefly go through and describe her work, Reconciling Legal and Technical Approaches to Algorithmic Bias, which essentially at its core analyzes whether technical approaches to algorithmic bias are compatible or consistent with US anti-discrimination law. And then Alice, near the end of the paper, recommends sort of a path forward to reconcile or to deal with some of the challenges that she raises in the paper. The three main contributions of the paper, as Alice outlines at the beginning, is first to illustrate the technical challenges of mitigating algorithmic bias and to sort of map some of those technical challenges onto the law, US anti-discrimination law. Secondly, to assess potential constitutional concerns with probably the most effective, in her estimation, way of mitigating algorithmic bias, and that is the use of protected class attributes or variables in machine learning models to mitigate algorithmic bias. And thirdly, to lay out a potential solution or a path forward to allow the use of bias mitigation techniques while conforming to existing legal standards in US law or US anti-discrimination law. So those are the main contributions of the paper. And really, it's nicely set out through multiple sections. Alice begins in section 1, providing some, in my view, pretty straightforward definitions of some of the core concepts that she deals with throughout the paper. So algorithmic fairness, algorithmic bias, algorithmic decision-making. She essentially defines algorithms in this paper or approaches them as machine learning algorithms. Notes that the definition for algorithmic bias is hotly contested, but I think her definition is fine. She defines algorithmic decision-making as sort of algorithmic bias as algorithmic decision-making processes that that emerge due to demographic characteristics or other factors that are problematic from a societal perspective. And she also defines algorithmic decision-making as well. I find the definitions that she uses are fine, well laid out, and well explained in this section. And then goes on to provide a few examples of algorithmic bias. Those familiar with this area of research and scholarship will likely be familiar with them. She mentions the COMPAS risk assessment tool, which was shown to be discriminatory against Black defendants in the criminal justice context. She references, for example, Amazon's resume filtering tool, which was shown to be biased against female applicants due to skewed data sets that the algorithm was actually trained on. Those are some of the more high-profile examples to give some context to algorithmic bias as both a technical, legal, and societal challenge. Then she moves on to, in section 2, outlining some of the technical challenges facing our machine learning approaches to addressing algorithmic bias. She goes through a range of different sort of techniques and approaches, so proxy variables, fairness, accuracy trade-offs, and she raises problems, for example, of intersectionality. So people's personal traits, so protected class variables being race, ethnic origin, sexual orientation, what the core sort of personal traits that one cannot make decisions as an employer in the discrimination context. If one does and discriminates on that basis, then it would be illegal under US anti-discrimination law. And she goes through very nicely in section 2 and outlines many of the technical challenges. So for example, attempting to eliminate the use of protected class variables from models and from machine learning using close proxies. It could actually, in order to reduce algorithmic bias, can actually lead to exacerbating the bias, because omitting variables can lead to proxies having outsized influences on decision-making processes. She also talks about intersectionality. Personal traits are not additive. When you add different intersectional identities, be it race or gender or sexual orientation, that creates new complex dynamics that may not be able to be properly taken into account in a new model that's attempting to address systematic bias within the system. Then she moves on in section 3 and reviews some of the key jurisprudence in the one area of US anti-discrimination law that's been more open to allowing the use of protected class traits in the context of machine learning decision-making or algorithmic bias. That would be variables, protected class variables, and that is in the affirmative action context. The challenge there, as she really well lays out in that section is that over time, US anti-discrimination law has been decision-making based on categories and classifications. Instead, a anti-classification norm has become the progressively over time, the central norm of the law. And that means mitigation techniques, which are the most effective, the sort of mitigation techniques that rely on those variables, protected class variables, are going to be treated with suspicion by the courts. And so in light of these challenges, she sets out in section 4, offering some potential resolutions. And her solution is to point towards a new area of research that's actually hotly contested and debated within machine learning research, and that is causality. So a greater focus on machine learning decision-making that's not just attempting to use statistical modeling, making decisions based on associations and data, but reworking and refocusing AI and ML research on causal inferences. She references, for example, the work of Judea Pearl and some of the challenges in this area as well. But I like this as a solution too, because causality really does go to the core of what anti-discrimination law, as it was built up for over decades, was really about. Are there employer practices that are a causal reason for discriminatory treatment or impact for certain protected groups? And so she lays out some of those, that is a pathway forward, providing a nice outlay of the technical literature and then seamlessly combining it with her insights from the law. That's the summation of the paper. I think as I said earlier, it's really well argued. It's really nicely written and also sophisticated in its analysis. A few of my more constructive comments, and again, I think this is a great paper, and a lot of my, I think, constructive feedback is really going to be just suggestions to expand parts of the analysis, just parts that I think would strengthen it and make it a little bit more persuasive. But I also understand this is already a long paper, so take that into account. So for example, in section 1, Alice, when you talk about some of the debates and the contentions around the definitions, you have some of that footnoted, but it'd be great to have a little bit more, as you know, some of how some of these definitions are hotly contested. It'd be nice to see a little bit more in that section about some of those debates, just to give some context to the definitions that you actually use. In section 2, where you go through some of the technical challenges, I think here it would be nice to hear a little bit more. Near the very end of that section, you note that there have been methods that have been developed that use proxies, but they've been less effective at mitigating bias. And you provide a brief explanation there, but it would be good to have a little bit more in that section, again, because it seems something positive or possible there as a solution, but you sort of like pass by it a little bit quickly. I think that's around page 31. Section 3, I thought, as I said in my description, was an excellent explication, I think, of the relevant law on point. And here, I think where I'd love to see a little bit more of it, maybe this also fits into section 4, is a more normative analysis of the jurisprudence. So you very well laid out the fact that this anti-classification norm has become the core norm of the law. Courts are increasingly suspicious of classification based on protected class variables and attributes. And I think here it'd be nice to not just set out the law, but provide maybe, and I think maybe this also goes to your section 4, maybe that's the better place for this, because I think what your paper really shows is that there's a real core problem with anti-discrimination law as it is today, and it really cannot, this anti-classification norm is really problematic for dealing with the challenges you raise. And maybe a stronger, more normative analysis of the case law here, I think would be helpful. Maybe relying, for example, you mentioned the Ricci case, De Stefano, the 2009 case, you briefly mentioned it, but I think in that case, it really shows the challenge and the conflict between the anti-subordination principle and the anti-calcification principle that's deeply embedded in anti-discrimination law. And I think really analyzing and doing a little bit more looking at that case, because it really shows the core problem with the law as it is. Analyzing, maybe critiquing the way the US Supreme Court reasons in that case, or using it maybe as a foundation for sort of a legal path forward in addition to the technical one you provide in Section 4, I think would be also nice as well. My last constructive bit of feedback is just in Section 4, talking about your causal inference or causality as in you focus. I think this is really nice. My only suggestion here is to do a little bit more here to describe some of the existing contentions around this debate, around causal inference itself, more generally in statistics, but in particular within AI and ML research. And you mentioned, Judea, Pearl's work. It would be great to hear a little bit more about his, his hierarchy, his contentions, of course, that all machine learning is essentially just at the statistical inference stage and the hierarchy, and we really need to get more real-world concrete. And you discuss a bit of that, but I think to make that last section a little bit stronger, more persuasive, especially for technical readers who are aware of it, I think you want to add that to give a little bit more context to causal inference and why, up until this point, it hasn't really been, at least in Pearl's view, been a focus of AI and ML researchers who have instead been focused more on statistical inferences and examining and developing machine learning systems based on inferences and associations in the data, as opposed to, as Pearl would say, connecting those kinds of analysis to real-world, concrete real-world analysis that gets you to systems that are going to be better dealing with systematic bias, which you're attempting to deal with. So that's all I have for the summary and some of my constructive suggestions. But I think it's a fantastic paper, and I'm really thankful for the chance to read and comment on it.
Thanks so much, John. I really appreciate your really kind words about the paper and for your constructive feedback as well. Thank you for emphasizing the importance of interdisciplinarity in this space. Definitely something that motivated me a lot in writing this paper was in my work at the Partnership on AI, I interact with a lot of machine learning researchers throughout a variety of different organizations. And this issue consistently came up in their own experience in terms of trying to implement algorithmic fairness measures in industry when it came to actually getting approval from legal or compliance. That often came up as an issue. And also from my own experience as someone who's previously done research on affirmative action jurisprudence in particular, it always struck me as being very interesting as I read the machine learning literature, how much this was an area that I felt folks weren't talking about. And if we weren't careful in terms of how jurisprudence and policies develop in this space, very likely the vast majority of approaches that have been proposed in the machine learning literature might actually be illegal if they were ever contested in court. So that's something I think, from a societal perspective, we certainly don't want. There have been growing calls for folks to actually take action on algorithmic bias. And I think this is sort of a missing piece that people haven't necessarily realized, that one of the major hindrances is actually the legal complexities that arise when you actually try to mitigate bias in practice. So that was kind of my motivation for this work, and I think it's one of those areas where kind of being able to see on both sides makes it pretty clear that this is an issue. So thank you very much for calling that out, John. And then also thank you as well for pointing out the aspect on the normative analysis of the jurisprudence. For this piece, I was mostly kind of looking at, what can the ML community and what can policymakers do in terms of taking the existing jurisprudence as it is and taking some of the existing anti-classificationist stances as they are. But truly, I think the issue that is highlighted through this tension between algorithmic bias mitigation measures and the desire to be blind to protected class attributes also goes back to just much broader questions about anti-subordination, anti-classification. And I think the algorithmic context just makes it very stark that a strict anti-classificationist stance has a lot of unintended consequences. And it's interesting to me how in the algorithmic context, essentially these tensions and trade-offs are made very stark because of the mathematical nature of these algorithms. So I think one maybe motivation that wasn't quite explicit enough that I should make clear in the piece is personally, I would have the hope that if we do see more litigation or more lawmaking around algorithmic bias, that this does call into question the court's anti-classificationist stance and does show some of these contradictions in recent jurisprudence. Like in, for example, just the anti-discrimination law context, we saw a huge change in the Bakke decision where the compelling state interests that legitimized affirmative action in higher education became diversity rather than historical discrimination, which is in contrast to, say, in the government contracting line of cases where historical discrimination remains a compelling state interest that can allow for more affirmative action policies around the granting of government contracts. So it's kind of interesting how there have been these debates for a while, I think, in terms of that juncture in the court's jurisprudence and what the consequences for that has been for affirmative action. But I think folks haven't necessarily often drawn that connection specifically to the algorithmic bias mitigation context and seen all of the challenges it might create there. So I'm hopeful that this piece might spark some further discourse in this space. And I think there are also a variety of jurisprudential solutions that can occur alongside what I propose in this piece, which is a little bit more of a technical solution in terms of having more of a causal framing around algorithmic bias mitigation measures. And all your other points, I take very much as well and think that they're great, and we'll go back through and do my best to build out those sections. So thank you so much for your summary and for your constructive feedback, and again, for your very kind words about the piece.
Really, what this paper does is render really salient some of the problems that have been built into U.S. anti-discrimination law, which have been papered over with some of the older cases where we, this suspicion and focus on anti-classification, and that has become the central norm, and it's prioritized over anti-subordination. And I think Alice rightly points out in her response, like, I really think this paper renders that problem, that conflict with addressing these so clear and so salient, and it may be the thing that finally encourages greater reconsideration by the court of its jurisprudence in this area. So I think, yeah, it's the anti-classification norm overly simplifies a lot of the challenges concerning discriminatory practices in this context, and I think this paper, interestingly, in the ML algorithmic bias context, really renders some of the simplistic assumptions of this way of doing discrimination law more salient. That's it.
All right. So very, very big thank you to both Alice and John for joining us for this digital edition of We Robot 2020. This is the part where if we were at an in-person conference where people would be getting up to the microphone to ask questions. So we invite all of those of you watching to sound off in the comments and have a conversation. Maybe get in touch with Alice and John as the discussions around algorithmic bias and regulatory and legal contexts continue. So from all of us here at We Robot, thanks so much for participating. Thanks for watching. And we hope to see you in person someday soon.